Good afternoon, everybody. We're here on the TRO hearing in this matter. I expect Judge Krause will be joining us any moment now, so when you see her appear, turn your cameras on, but remain muted until she has to speak with you. Mr. Church, you've been on here for a while. You were aware it was an 11 o'clock start time, correct? Okay, I just wanted to make sure. Okay. All right, and then with that said, Judge Krause should be appearing any moment, so look for her square to appear and we'll get underway.
Tom, you were on mute. I couldn't hear you. I saw you talking, but
That was my bad. Glad we're doing this practice run.
Good morning. Okay, so
Good morning,
let me start with a few preliminary matters. Do we have a court reporter? Do we need a court reporter?
Plaintiff is not, we have not retained one, and we're not asking for one at this point.
Okay, just making sure because the court reporter is not at your disposal. So I wanted to make sure everybody was aware of that. Which leads me to my second point. This matter, because it's taking place on Zoom, is being live streamed. So it will be available to be observed by viewers on my YouTube channel. So congratulations, you're all influencers. I say that for a couple of reasons. Number one, there is a clear notice on my YouTube page where this is being live streamed. Do not record. I have not received any Rule 22s requesting the opportunity to visually or audio record these proceedings. That's number one. Number two is that is not an official, that recording, to the extent that it exists only as a function of YouTube retaining it for some period of time. It is not an official record of these proceedings, and it is not to be treated as an official record of these proceedings. I just start by saying that. So here's what we're all here for, and I'm going to get announcements real quickly, and then we'll get started. This is down for an emergency TRO hearing in the matter of RSRA Ventures LLC doing business as Air Freshener Depot number 2 versus Rodney Green and Keith Meadows. I know from looking at the pleadings that I have Mr. Church here, and I believe also Mr. Arrington here on behalf of RSRA Ventures. And then Mr. Hyman, I believe you are here on behalf of Mr. Green and Mr. Meadows. Is that correct?
That is correct, Your Honor. And for one other housekeeping matter,
Sure.
to the extent that we need Lieutenant Cornelius to offer any testimony for the court, based on your announcement that's been recorded, I would like for him to be able to keep his camera off because he is narcotic. That's the same thing they had, like the news media yesterday at our administrative hearing, and the camera didn't show his face or anything like that. So I would respectfully request that he be able to keep his camera off if he has to offer any testimony today.
Yeah, it seems like a reasonable request. We will fight about that bridge when we get to it, Mr. Hyman, if a dispute is necessary.
Okay, thank you.
No problem. So I'm going to start by telling y'all, as I frequently do, I'm going to start by telling y'all what I think I know about your case. I'll also, just in the interest of full disclosure, make sure everybody is clearly aware that, of course, I am aware that Mr. Arrington is a Fulton County Commissioner. Obviously, y'all are all aware of that. I don't think that it limits my ability to adjudicate this matter, but I do want to just make sure and draw that to everyone's attention. Number one. Number two is I did see, I think, a media story on WSB yesterday about a hearing that y'all had notified me would occur. So I just want to let you know, I've seen some brief media coverage of the fact that a meeting did occur yesterday. I believe in front of the city manager regarding the license that is at least partially at issue in this case. What I think I understand is that at some point the city of South Fulton, excuse me, police chief, that their police force went in to RSRA Ventures operation and seized a bunch of materials that are alleged by, I guess, Police Chief Meadows. If I'm getting those names wrong, if one is the police chief and the other one is the CFO, I apologize. But that the police chief asserts are illegal substances under Georgia law. And as a result of that, the CFO of the city of South Fulton revoked RSRA Ventures license to operate, business license to operate in the city of South Fulton. My understanding is that I have been requested in both the original filing of the petition as well as the active motion for a temporary restraining order to order that the license be reinstated pending a hearing. And we're going to talk a little bit about whether that is relief that is still necessary, given that a hearing took place yesterday. And also to, moving forward, prohibit the defendants from threatening or initiating arrests or seizures based on the possession, sale, or distribution of hemp-derived cannabinoids, which my understanding is that from the petitioner's perspective, all of the materials that were seized are legal materials because they are hemp-derived cannabinoids that contain less than 0.3%, et cetera. And all that's getting very far into chemistry and science that I didn't go to school for. I went to law school for a reason, but I trust that you will all dumb it down enough for me to understand it effectively. So that's where I think we are. So let's start with procedurally, what do we really need to deal with today? Because in the interim between the court being made aware of this and receiving a request for an emergency hearing, the city did in fact hold a hearing regarding the license and will issue a ruling on that, I think within 10 days is my understanding. And presumably there would flow from that appropriate appellate remedies that RSRA could pursue if in fact the license is continued to be revoked or if the decision to revoke is upheld, whatever that looks like procedurally. Mr. Church, Mr. Arrington, who am I going to be hearing from on that matter?
Your Honor, I believe that
Mr. Arrington, you're muted if you're talking, sir.
I'm happy to start on that part. I know Tom is specifically on the hemp farming side. Your Honor, I think a couple of things to address your point. Number one, the city council already took a vote and voted for this matter for this store to remain closed until they have a hearing on July 9th. So we went through with the hearing yesterday, but it really was a farce because the city council has already voted to keep the store closed. I don't even think the city manager has the authority to overrule a city council vote. And I don't even know how this matter got on the city council agenda, Your Honor, because we were supposed to have the hearing first. And then after the hearing with the city manager, then we would appeal to the city council. They actually they asked us if we wanted to waive the administrative hearing before the city manager and go directly to the city council hearing, and gave us a deadline. They told us, hey, if you don't let us know by Thursday at 5 o'clock, you won't be able to make the city council agenda. You won't be able to take advantage of that. And so, but somehow it miraculously got on the city council agenda. So while the hearing is good that they did it, and then of course, Your Honor, obviously we also think that it's too late, right? According to Rose versus Grow, 210 Georgia 664, Supreme Court, once a license is issued, the due process clauses of both federal and state constitution require notice to and the hearing of one to whom a valid license has been issued before its revocation. And so we submit that they should have given us the notice and the hearing prior to revoking it. But more to your point, we do not believe it is moot because the city council has already voted. And so yesterday's hearing before the city manager was really just a sham.
Right. And I'll let Mr. Hyman respond. I understand that's your position, but I think what I understand that RSRA's position is that the hearing process that occurs after a revocation has already occurred is an insufficient provision of due process, et cetera. And that's a conversation that needs to be had. But I guess my point is from just a purely TRO perspective, one of the elements of relief that was asked of this court was to order that a hearing occur. And now a hearing has occurred. And presumably that my understanding is, if I'm looking at my math correctly, the city manager is going to have to provide an opinion within the next 10 days, and that city council meeting on the 9th would give everybody an opportunity to know what the city manager's recommendation is going to be. And so I guess it feels like from a procedural perspective, it would be moot for the court to order a hearing that's already occurred. But perhaps there's a conversation to be had about the license itself, and what the status of it is pending the outcome of all of the process of that. So.
Yes, Your Honor. Thank you. Thank you. Yes, we would be asking you to allow the license to unrevoke the license, and until there is such time that there is a ruling, I guess, by the city manager. The 10 days of being open, that's 10 days of people being employed, and 10 days of revenue, particularly when they've lost almost 60 days of revenue now.
Okay.
And Your Honor, if I may just piggyback on that just a little bit, because I was the one who prepared the verified complaint and the motion for a TRO. And I think the court's question is a good question, right? What exactly relief are we asking for right now? Of course, we're just moving for a TRO, which is just 30 days, right? We're not asking for we are asking for interlocutory relief, but that's not what we're here for today. And so these 30 days that Your Honor could lift the revocation, it's not so much that we're asking Your Honor to give us a hearing right now, as Your Honor mentioned, something to that effect happened yesterday. What we're asking for is 30 days of that license being reinstated, and that would cover not only the 10 days of the city manager making her decision and her recommendation, but it would also carry us through that city council, because the city council is has told us they're going to hear us on July 9th. As Mr. Arrington mentioned, they already voted before our hearing with the city manager to keep the license revoked up until July 9th, which is why we felt this was emergency relief that was warranted. So I did just want to kind of narrow that focus to reiterate that we are asking just for 30 days of the license being reinstated. And in that time, the process that kind of went out of order in this case can kind of settle back into some kind of routine, statutory procedure where now things are going in the right order. Because as Mr. Arrington mentioned, you're usually supposed to get the city manager hearing before a vote by the council, and that didn't happen here. So the 30 days would let everything kind of reset and proceed in the right order, without, of course, these due process concerns of not having that hearing before the revocation.
Okay. I'm going to call on Mr. Hyman here in just a moment. Before I do, one last thing about the YouTube. So one of the reasons that we live stream this is so that people that want to observe but don't need to participate can observe the proceedings there. And the reason we do that is that it gets real clunky real fast when I start having a lot of people involved. And I'm seeing people join in. Also, I think, can't swear to it, but generally speaking, my notices of hearing that are by Zoom indicate that you're not supposed to share the Zoom link with anyone without permission of the court. So all that is to say, if you do not need to speak to the court or don't expect to be called as a witness to testify in the court, and you're not attorney of record, perhaps you could observe the proceeding on YouTube, just FYI. Anyway, Mr. Hyman, would you like to just sort of briefly respond before we get into the meat in terms of the nature of the requested relief that's being sought?
Judge, it's more than briefly, because this has been just a total mischaracterization. And starting with, we being the city filed this notice of filing exhibits. And I specifically did that and listed as Exhibit 6 our email exchange between my office and Mr. Arrington. And as the court is aware, the revocation notice was issued 8 days later after the raid, which was on March 9th. And because Attorney Arrington had reached out to me, the next city council meeting was May 28th. And as the court is aware, just like with Fulton County, under the Georgia Open Meetings Act, we have to publish and get the council agenda out, city council agenda out at a certain time period. So the cutoff date they was provided was to let them know, hey, let us know what your client would like to do, because we have the potential to get you on the May 28th agenda. And we said that you can ask your clients whether or not they want to waive the intermediate step, i.e. going before the city manager. And so in doing so, didn't hear from him, but I told our city clerk, go ahead and leave the title of the hearing on the agenda, because it's easier to meet the Open Meetings Act by having something published on the agenda than to not have it on there. He shows up, say, hey, my client wants a hearing. So that is how that got on the agenda, i.e. May 28th, trying to accommodate, with the say no good deed goes unpunished, trying to work with Mr. Arrington and his client. In fact, Mr. Arrington showed up, but counsel in executive session was handling some other matters, and he got frustrated and said, you know what, we're leaving. We drove an hour here and we're leaving. And what counsel did was merely saying, hey, we are going to maintain the status quo, what a status, which at that point in time, the letter of revocation issued, and we will address this matter in July, because counsel's out. I'm down here in Savannah myself, was out for the June recess. So that's how there hadn't been any missteps or miscues. Also, Judge, and it's been a while, like I said, I probably may have, I always ask myself, because people throw around this term all the time, due process, due process, due process. And as I mentioned in my reply brief, and even if you just type in the Westlaw, and I just found this today, and it's the case of Novin versus State Bar of Georgia, and I cite some other cases, but basically it says the definition of due process does not guarantee a particular form or method of, and it's a state procedure, in this case it'd be city procedure, but rather due process is flexible and calls for such procedural protections as the particular situation demands, in light of facts that due process, unlike some legal rules, is not a technical conception with a fixed content, unrelated to time, place, and circumstances. So I've also put some other cases in there under the due process just to address that. Due process is basically we give you time, place, and opportunity to be heard. And so also, Your Honor, from a technical perspective, really the threshold issue hasn't been addressed. Mr. Church alluded to seeking prospective relief as a way of getting around the city's official immunity, but just bare allegations or mere assertions is not enough to strip Chief Meadows or Green of any type of official immunity. That's another matter the court needs
Right,
to.
and I appreciate that, sir, and I'm gonna hear from you on that substantively.
Okay.
But right now, I was really focused sort of on
Okay.
the nature of the relief, because at the end of the day, TROs are, in my opinion, supposed to be only as restrictive or require only that action that is absolutely necessary to maintain the status quo until we can get to the more substantive proceedings. And so the main thing I like to start with is to be clear on what is the nature of the relief that is being sought so that I can have an understanding of what I'm considering. So
Okay, and another thing too, Your Honor, that is mentioned in my reply brief, is that also a TRO can't be used to undo an act. The act of their business revocation license has already been consummated. The other factor, as you're aware, is adequate remedy of law. To me, which undercuts their argument, if they believe that council has permanently voted, then they would have brought this as a petition for review or writ of cert, saying that there's been a final decision, but that hasn't been the case. Also, the city manager is not going to conduct a hearing that the city council isn't aware of and doesn't, as part of the process. So she's not acting as some rogue person conducting a hearing and city manager say, hey, we've made our decision. Why are you going against us? So all the previous argument, respectfully by Commissioner Attorney Arrington, that's not correct. And so here, like Deanna kind of alluded to, there's 10-day decision, and after that decision under code, they would have a right to then appeal to the city council, and the city council's first meeting will be in Tuesday, July 9th. And then they could meet this second and fourth Tuesday every month. So there's clearly an adequate remedy of law, and then TROs or injunctive relief is something that should be scarcely or rarely issued. So that's just my kind of brief spiel, hopefully addressing your question, Your Honor.
thank you, Mr. Hyman. Okay, so I think I've made my point, which is that the hearing, I think, is a train that has already left the station and not something that the court needs to concern itself with. Now, what to do with the license during the interim is, I think, an issue that's fairly before the court. Understanding Mr. Hyman has already alluded to the city, or I guess the party, the respondent's position that that train too has already left the station because it's been the license has already been revoked, and that the court can't use temporary relief to order something undone that's already been accomplished. And so we'll hear argument on that issue. And then I understand we do have to get into some of the factual discussion, because, for example, I'm assuming, could be wrong, but I'm assuming that the reason the city might have available to it Lieutenant Cornelius is to provide the court with with evidence and testimony about the purchase that he made, or purchases, whatever, which I believe are alleged in the various materials that I have. But I think, and this is where you can correct me if I'm wrong, that the fact that those purchases were made is maybe not a dispute. It's that the petitioners assert that the purchases were of legal materials, and the police department asserts that they were of materials that are not legal under Georgia law. So that's where I think we need to focus our efforts, I think, unless somebody's going to tell me that there's some dispute about the nature and scope of the purchases that were made by the officer.
Your Honor, I think one thing that
I'm going to hear from Mr. Hyman first. Yes.
I think one thing, and also is in a recent filing by Attorney Church, did an affidavit, which
I had a
One-
chance to review it this morning. Yes.
Well, the one thing, and like I said, I used to be in the court all the time. I don't get as much. I'm kind of more of a bureaucrat now. But the last time I checked, that you have to be one. You can't be a fact witness and an attorney. But notwithstanding that, his affidavit in paragraph 7, he does admit that the police department, because we did get samples tested, and there was products that were in violation or above 0.3%. There was planted material that the gross total was 20 of THC, but under the Delta 9 requirement was 1.89, which is in excess of 0.3. There were 2 other items that were in excess of 0.3. So we sent out to a private lab. So it's not just a issue of whether or not they say it's legal, but they actually did recover contraband and drugs that were above the legal limit. And so he's prepared, if necessary, to go to that. And also, the backdrop isn't just the South Fulton Police Department is somehow picking on this person's client versus so much as that there was actually a solicitation made. Hey, this is marijuana, it's the real stuff. And they're like, really? And so that's what set this ship sailing for the 2 under control buys.
Okay. Well, we're gonna get into all the facts of that. I just
So Judge, if I may,
Yeah.
I just wanted to bring out 2 points. Number one is we believe that the ordinance as drafted is unconstitutionally vague and ambiguous. 2, we believe that because these hemp products are governed by the hemp farming bill, that this is a violation of the uniformity clause of the Constitution of the state of Georgia, and
Right.
specifically, Rose versus Grove states that the holder of a valid license, which has been properly issued, may enjoin its revocation and the interference with its lawful business thereunder. And lastly, I have the video of the council meeting queued up in case the court would like to see what the action was that was taken by the council. There was no mischaracterization by me at all.
Oh, well, I don't really want to throw around the words mischaracterization, et cetera. I mean, I'm going to give everybody the benefit of asserting and attempting to vindicate their respective clients' rights in good faith. So having said all of that, what I do think that we need to start with the issue of sovereign and official immunity. I'm going to start by saying, I'm going to call on Mr. Church to start, and then I'll let Mr. Hyman respond. I will start, however, by saying that one concern I have is that it's one thing if we're asserting that the police chief individually, right, was acting outside of his lawful authority, because theoretically these are, if it's shown that these are legal products. I have more concern, though, if the basis of the CFO acting improperly is because the municipal ordinance itself is unconstitutional in that it does not provide due process, because I think some of the case law you all have cited to me, we can have a conversation about if the statute is unconstitutional, then he's acting outside of his rights. But if what we're really doing is challenging the constitutionality of the statute, then do we have a proper party? And is this the proper forum? And then are we right back into the sovereign immunity issue associated with the constitutionality of a government law? So that's just my 2 cents for what I understand for some of the issues to be. And with that, I'm going to throw it over to Mr. Church to begin.
Thank you, Your Honor. I do appreciate that. And first, I want to answer the court's questions right away, but first, let me just assure the court that we're not asking the court to really venture to any uncharted waters. There are some novel issues in this case, particularly surrounding the business license, but at the core of this case is whether Air Freshener Depot is violating the law. And fortunately for the court, there is plenty in the history of Georgia and Georgia hemp laws to look at, including in the Superior Court of Fulton County. As you probably
I'm familiar with Judge Eaton's ruling and Judge Schwall's ruling, and I'm familiar with some of the history associated with efforts to enforce or not enforce the hemp laws as they exist. So
Absolutely, Your Honor. And this case is a little bit different because out of all the cases I've seen, this is the only one in which the city or a local government has suspended a business's license based on these kind of allegations. So first, let's dive right into the sovereign immunity and official immunity questions, which, by the way, were also presented to Judge Eaton, and he denied their motion to dismiss, and were relatively the same kinds of arguments that are being raised here. Now, I do want to be clear that looking at Lathrop, for example, which is that case that lays out exactly what the difference is between an official immunity defendant or official capacity defendant and a individual capacity defendant. And Your Honor is right. One thing that you can do is sue an individual capacity defendant when they act outside of the scope of their authority, which is what we call an ultra vires act. But it's not limited to just that, but also unconstitutional acts. So I think the way we tried to plead this case is there is certainly an unconstitutional dimension about the ordinance, but even if the ordinance says what it says, this was an ultra vires act because they suspended the license, whether they have the right to suspend it without a hearing or not. They did so based on reasons that are not allowed, which is that these people were selling products that were alleged to be illegal. So I do think that we have pleaded this in an appropriate way. I did not see Lathrop cited. I did not see anything cited in the defendant's motion that even recognized this long-standing doctrine in Georgia law that you can sue even a city official doing something under the color of office, under color of the of the law. They could be doing a quote unquote an official act, but it's really about the nature of the remedy sought. And so that takes me just a little bit to something Mr. Hyman said when he talked about, we can't undo something with the TRO, and there's already an adequate remedy available. Looking at the statute for the TRO and for declaratory actions in general, looking at the case law, it doesn't matter whether there's another potential avenue that can be pursued. What matters is the nature of the relief sought. And here, this is not something that's covered by sovereign immunity because sovereign immunity protects the state, and it protects the state and state officers against a court. The reason it exists is because the legislature doesn't want the court to restrict one state official for something they did and have that apply for everyone else in the state who could be operating under very different facts. So at the end of the day, what we're asking for is strictly limited to two individuals in this case. And it doesn't matter that there's another potential procedure that we could go through. It doesn't matter that they were acting as they thought pursuant to their authority or under a municipal code or citing some kind of law or in an official capacity. It matters what the relief that is sought. And so, and Mr. Hyman also mentioned about the allegations are not properly put forward to be able to allege an individual capacity claim, but it has nothing to do with the allegations. It is about the relief sought. And because we are not seeking to bind the entire state or any other state officials through the relief we're requesting, there is no sovereign immunity. And I thought that the argument for official immunity is even weaker because the court in Lathrop, the Supreme Court in Lathrop was extremely clear. We've never heard of the doctrine of official immunity being applied towards anyone in an individual capacity. So I think if Your Honor finds that this case is properly being brought against individual defendants, which we think it is, we don't think there's anything in the motion to dismiss that would undermine that, then there is clearly no immunity. If Your Honor thinks that this is actually an official capacity case, then Your Honor would have to make a finding that what we're trying to do is actually restrict the entire state of Georgia or every official. And that brings me back kind of to my main point, which is we're just here asking for 30 days of relief so that things can slow down, so that we can reopen, because right now the company's bleeding. And hopefully in that time, maybe we can work this out. But right now, we're not in a position to do that because right now the business license is gone. And what Your Honor can do, if Your Honor thinks you can't reinstate the license, although we think temporary restraining order is just kind of a term of art for prospective injunctive relief. It's just much shorter. It's only the 30 days. I don't think I would hear Mr. Hyman dispute that through an interlocutory injunction, you could reinstate the license. But what Your Honor can do is say, here's what we can do. No raids based on strictly hemp. Like if there's a bona fide reason to believe that someone's selling marijuana under the counter or an illegal drug, we're not trying to interfere with law enforcement when it comes to legitimate law enforcement aims. But what Your Honor can do is say no further raids based on hemp. And two, even if the license is revoked right now temporarily, the city cannot act on that if the business reopens. So it's not reinstating the license, but it is putting that pause. And again, this goes back to the status quo, which is what Your Honor said correctly, is what a TRO is all about. The status quo for 2 years now has been this company in the open, publicly selling safe and legal products, and that we hear about an undercover investigation. I made this point yesterday before the city manager. Officer Cornelius, anyone else from the South Fulton Police Department could have walked in there and just purchased whatever products they wanted. There didn't have to be an undercover capacity. And in fact, this business has sold a lot of products to a lot of South Fulton police officers. And so let me end on this note, which is what we're seeking here is very narrow, 30 days of just resorting to the status quo, which is the business can remain operational. And if there are strings attached to that, for example, you can reopen, but don't sell any hemp products for now. I would have a problem with some of that, but maybe not certain products that are specifically at issue here, right? Certain brands, because they don't just sell hemp products. They sell tobacco products, hookah products, cigars, they sell pipes, they sell backpacks. It really is not a one trick pony kind of store. They provide a lot of services and products. And so if Your Honor would, what we're asking for is to deny the defendant's motion to dismiss, which has already been rejected by courts all across the state in this kind of similar context, minus the business license aspect, and then to grant this temporary 30-day hearing, this 30-day restraining order, and to schedule an injunction hearing so we can fully flesh out these issues, put up our expert, they can put up theirs. And I will just end on that note, and that I pointed it out in my affidavit that some of these products tested ever so slightly over that 0.3%. I do dispute Mr. Hyman bringing up a completely irrelevant metric, which is the total THC. He mentioned it was over 20%. Absolutely irrelevant. What matters is the amount of Delta-9 THC in these products. And as Mr. Hyman, I think, would acknowledge, and as Officer Cornelius did acknowledge, these were barely over the limit. And in fact, the majority of products that were tested by their expert came back passed, completely legal.
Okay, a couple of questions before I hear Mr. Hyman's response, or if Mr. Arrington's going to jump in, although generally I do not like it when somebody double teams one lawyer. But in any event, one question I do have is you've said several times that the main relief you're seeking is this 30-day pause on, essentially whether I reinstate the license temporarily or enjoin the city from penalizing. Here's my question. Where we are now, why is 30 days relevant practically, given that the city manager is going to come out with a decision after you've had an opportunity to present your side of the case within 10 days from yesterday, right? So by the end of this month, the city manager will have issued a decision, and then the city council will have a meeting on July the 8th where it will have the benefit of the city manager's decision, and presumably if it's y'all will have an opportunity to present some argument or something at the city council, and then the city council will vote. And one option would be the city council could vote to reinstate the license, or it could vote to continue the license in its revoked status. Why is that not the appropriate, right? The outcome, not 30 days, but until the city council votes, just from a practical perspective, because what I don't want is a situation where I say 30 days, that gets us to July 21st, but on July 10th, the city council, after having given 2 opportunities at due process, maybe not in the right order, right, says, no, your license is revoked, and now you have appellate remedies.
Thank you, Your Honor. Certainly, it doesn't have to be 30 days. If Your Honor wants to take a more conservative approach, it could be through that city council date. And we would frankly like all 30 days, but we'll take whatever Your Honor is willing to give us because, again, this is about the business bleeding losses. That said, and I haven't really had a chance. I didn't put this in my affidavit. I wanted to talk to Mr. Arrington about this first. It's something I could get out of Officer Cornelius if he's going to testify. But we do have some concerns. And let me first say this. I desperately hope that I am wrong here and that the city manager takes in all that we provided yesterday. We provided a lot of test results that we have. We provided evidence that other stores in the community were selling the exact same thing. We presented a lot of information that I don't think the city had the benefit of having before they did these raids. So hopefully I'm completely wrong here. But there is, I think, a concern that the city might have prejudged this situation, especially if they're pointing at 3 products that barely were over the limit and saying this is a criminal business that needs to be shut down. I will say that one thing that caused me some concern during the meeting yesterday is when I was asking Officer Cornelius some questions, the city manager actually interrupted and provided an answer for Mr. Cornelius, Officer Cornelius. When it was about,
Forgive me, Mr. Church, I understand all those things, but again, even if y'all think it's out of order and even if y'all think it's not meaningful, at the end of the day, a process has started that enables the business who's been affected by it to take issue with the resulting decision that's made and to take issue with the manner in which it was made and whether it provided appropriate remedy substantively. That's all something that will follow from the outcome of the city manager's decision and then the outcome of the city council's resulting decision. And so while I understand you might have those concerns, I feel like at least from the business license perspective, that once the city manager issues a decision and then the city council acts on that decision, there are clear remedies that flow to RSRA. Granted, they take time, and during that time, RSRA would not be operating assuming that those decisions are adverse to RSRA. But there's a clear process that would be followed that doesn't require us to go out of order to the court on a TRO. That's the only reason I'm asking about the procedural relief. But again, let's go back for now. I've heard from you on the issue of official immunity and the issue of sovereign immunity. And now I'd like to hear from Mr. Hyman on that issue. Yes, Mr. Arrington.
Judge, if I could just add one brief point. I think the reason that we were asking for the 30 days is because they've been shut down since May 1st. And so given the fact that it's been over 45, 50 days that they've already been shut down, we did not think the 30 days would be unreasonable, but certainly we understand that the court is only willing to take us through the council meeting.
Yeah, it's not necessarily the council meeting, it's whatever decision arises from the council meeting, because I mean, I assume we all understand that if the council's decision is adverse to RSRA, then there's a clear procedural process that they can follow to appeal it, and it's probably going to end up right back in my lap again, but it will be procedurally postured in a different way. And so what I don't want is for the final decision of the city council, presuming it is adverse, and votes to continue the revocation, competing with an interlocutory order of this court. That's all I'm concerned about in terms of the timing of any order that I might enter. Mr. Hyman, if you would address the issue of the official and sovereign immunity so that we can deal with that motion to dismiss and then either be done or proceed on to the merits.
Judge, I think you were on the right track earlier when you started to kind of announce. I've been doing municipal government law for a little over 30 years. And what Mr. Church mentioned as state, the immunity of sovereign official immunity also is applicable to counties and cities. So what happens is that if a person such as the Chief and Green are acting in their official capacity, then case law says that that's the same thing as city, i.e. then they're sovereign, they're entitled to sovereign immunity. Now, if someone is, then you say, well, I think that they were doing things in addition to acting in their physical capacity, so I want to sue them in their individual capacity. The law then says, okay, if you would not want to sue someone in their individual capacity, that they are entitled to official immunity. And where they're not entitled to official immunity is where their acts, and you mentioned ultra vires or willful wanton, those are, or basically some type of sinister intent, and I mentioned that in the brief. So basically, even if you've named them individually, there has to be some evidence indication that they're acting willfully wanton, or basically ultra vires kind of a word, but something to that effect. And you just can't please say, okay, it's the relief that we're seeking that controls, because whatever relief you're seeking has to be supported by facts. So if you're saying that, okay, Lathrop, or even the SAS case with Mr. Church is familiar with, or Sustainable Coast, normally when you're talking about prospective relief, you'll be looking at a situation to where, say, I think one of the cases was the tax commissioner, to where was deemed to be acting ultra vires, and that he would be repeatedly collecting taxes in the future. And so they wanted the prospective relief of preventing him from collecting those taxes based on the inappropriate ordinance that he was operating under. That was a prospective relief. But outside of that, what is the prospective relief where you have a police chief that they had probable cause, they executed a search warrant, and then unlike the other cases that Mr. Church, because he was surprised, the GBI is slow. So we sent the
Tell me, you're not telling me anything I don't know. I routinely have to worry about criminal cases getting to trial because we haven't gotten GBI testing results.
It was like over 1,000, I think it over 1,140 ounces of products that was seized. So there's more products that will be tested, but they sent out a sampling, and they did come back as Mr. Church over the 0.3 threshold. So that lets us know, or the court know, that they weren't just out there targeting Mr. Church's client, and that there was a legitimate basis. And so that means that they would be entitled to official immunity. Now, as it relates to what they're proceeding under now, the court is correct, is that you'll have a decision within today's city manager. They have a right to appeal to the city council. And at that point in time, then there would be a petition for review that would come to Superior Court, and then, could go up the appellate chain. But there's been nothing in the verified complaint that would indicate what prospective injunction or acts that you're seeking to enjoin that would they wouldn't be entitled to official immunity.
Right, but isn't official immunity typically concerned with actions for damages? I mean, we, as opposed to some effort to restrain that official who's been sued in their individual capacity from engaging in that further action again?
That's what the court alluded to, but and that's why I beg the question, what future action, we're not talking, what future action are you seeking the prospective release to enjoin?
I understand the request to be to enjoin them from further raiding or restraining the seizing materials or restraining the operation of the business if what they're selling is legal product.
And so I put in my brief that you cannot do prospective injunction if it's just a threat of imminent harm, bare allegations of mere fear, things like this. You can't even do it can't be too speculative to do. I could understand if, for example, we came back with all the product was 0.3 or less, and we say, you know what, we're going to try again. We'll keep trying until we get something like this. But the fact that, and Mr. Church will indicate that in the hearing, I made sure that he got into the record the products that did pass. I wasn't trying to sandbag or snowball anybody. All the products came back, whether or not they tested no THC, they passed, and all that got put in the record yesterday. And so that's the point, is that what future actions, basically you're saying that, okay, right now you do have a client that has sold illegal products as test results, and that you want to enjoin the police chief from going by there and make sure they don't have any other legal products. That is a very broad speculative prospective remedy. but we're here for what is the actions already taken. That's another point too. He's trying to get around the fact of we're here that the revocation is taking place. Who was participating in the revocation of business license, that has already taken place. And so there's this notion that if I just say, hey, we're going to seek prospective relief, that somehow they're not entitled to official immunity for the acts that are already taken place, they would be entitled to official immunity. And then it's too speculative, or am I overreaching the request of, hey, just let them operate basically what they can't do in the affirmative, they're trying to do in reverse. Well, you may not just be able to order the reinstatement, but just say that they can't enforce them operating without a license is really what they're saying.
Well, one question I do have, though, I understand that the issue associated with the business license makes this slightly distinct from some of the other cases that Mr. Church has mentioned. I think the most litigated one, and the one that people I think are most familiar with, was came out of Gwinnett County, I believe. How is this immeasurably different than that one, given the outcome of that case, at least as to the issue of immunity? Because I mean, I believe in that case was the suit was to enjoin and restrain the district attorney of Gwinnett County, who was attempting, I think, it was the district attorney of Gwinnett County, who was attempting to prosecute or, investigate and charge and prosecute people associated with the sale of similar products. How is this different measurably from the immunity perspective? Because I would imagine factually your argument from the enforcement perspective is, well, one, we have a license, and two, these have tested in a way that we believe they actually are illegal products. I understand that. But from the immunity perspective, how is this case different from the one against the district attorney in Gwinnett?
Really, I think if we're talking about the same case, that was a SAS case versus the state. Sir. Reading that case, and that the difference is this, Your Honor, is that actually the SAS case really clarified that if you're seeking paragraph 5 constitutional sovereign immunity protection, then you can't name any other individual in that suit. It has to just be the Gwinnett County, in that case, in that case, they named the district attorney. And they said, by virtue of you adding this other individual, and by their nature there, you have somehow breached or abrogated your right under sovereign immunity under paragraph 5 Constitution. And in some form of dicta to say, however, this is not to say that individuals in a prospective remedy could not be enjoined or action taken. And that's what it left with. So then you now have to say, okay, well, let's see if we can get around somebody's immunity by saying, okay, we seek to enjoin them prospectively. And where we are now is that the actions already occurred. They didn't name the city, so that's how they tried to get around it. They only named the individuals, but the distinction is that the facts that they're trying to allege are not prospective remedies. They're facts that have already occurred. That's what's distinct. Those facts have already occurred. That sets the base that they would be entitled to immunity. The chief is already, through his department, already taken the action. Mr. Green's already taken the action. Those facts have already occurred. And so for those, the fact that they involve some degree of discretion, which will go into the official immunity jar or box, that means they'd be entitled to immunity. Now, like I said, if there was a showing that, okay, they somehow were acting willful or wanton, then there could be a prospective remedy fast out of that, hey, I anticipate them coming back next week.
Well, but it's not just willful or wanton, right? It's if they're acting in a manner that's not authorized by law, or acting in a manner that is willful or wanton. And I don't think that the petitioners in this case are arguing that the city, or excuse me, that Mr. Green or Mr. Meadows are acting willfully and wantonly with the intent to injure somebody. It's that they're doing things that they're not authorized to do by law.
Yeah, but it has to be something played more than just that general allegation. That's really the point. And that's why I cited in my brief that you just can't have this just kind of general conclusory allegation and satisfy the requirement.
Okay. Thank you, Mr. Hyman. Mr. Church, I'm going to ask you one follow-up question, similar to what I asked Mr. Hyman, but on a different topic, which is one concern I have is that the presence of this business license issue does make this case different in one way. And so if we're talking about immunity based on, I think I understand, and I think this is ground that has been trod by other courts relative to the police or a criminal prosecuting authority seizing what are otherwise legal, allegedly, products, right? That would be things that they're not authorized to do by law. But I'm a little more concerned that even if it didn't happen in a way that y'all think is appropriate, that the CFO absolutely is authorized to revoke licenses, though presumably for reasons that are, lawful. And I'm wondering, I'm concerned that might make a difference relative to the effort against the CFO related to the license versus the effort against the police for their efforts in the case.
Yes, Your Honor. And I'm not trying to duck that question. I do think it's a good question when it comes to how do you fashion relief for the TRO or for the injunction. I don't actually think it has anything to do with the immunity. However, what I will say is, and maybe this kind of addresses both concerns, is going back to what can the court do and make sure that it fits with the fact that the court will take it at face value that the court can't undo an action. I don't necessarily dispute that, but I think the answer is to fashion narrow relief that says no further adverse action by the finance director, who is the person that makes these decisions about the license for these, 30 days or until the council meets. Also, one thing I would note is just because I just got these notifications, and I am sure that this was not intentional, but we were not served with any copies of the reply brief that was filed by the defendants. I'm just opening that up now, so I have not had a chance to review that or the exhibit list. I don't have an issue with the exhibit list. It's what they produced yesterday at the meeting with the city manager, but I would just note I have not had an opportunity to read this reply brief. That being said, I still think I'm prepared enough.
Just FYI, in fairness, since we are on the record, I received a copy of that reply brief along with the exhibits yesterday at 4:59 p.m. and by email from Mr. Hyman to my staff attorney, and you and Mr. Arrington and Sarah Kelly of the city of South Fulton are all copied on that email. So just FYI.
Okay, and maybe I missed that. It was kind of a crazy
Lots
day
of moving parts. It's late in the day. I get it. I just wanted to make sure.
Certainly not trying to make any accusations. And again, if I missed, I assumed it was inadvertent anyway. Regardless, I think that's fine. So I just want to kind of cover and respond to some of the specific points Mr. Hyman was making. Now, as Your Honor knows, we're at a motion to dismiss, so everything that we allege in the complaint has to be taken as true. This distinction about were they acting in their official roles or is this based on actions taken? None of that is grounded in any case law. In fact, the case law says the opposite, that regardless of whether they're acting under color of law or in their role as a sheriff or as a DA, they can still be sued individually. Again, it's about the nature of the relief requested. And Your Honor mentioned this, we've talked about the SAS Group case. So that was kind of a weird case procedurally because I was the attorney in that case, and we brought a lawsuit against the Gwinnett County DA in her individual capacity and the state of Georgia here in Fulton County. The state of Georgia.
It's very odd.
State of Georgia being
State of Georgia's got to be sued in Fulton County.
Gave us that venue, and this was a brand new constitutional waiver, as Your Honor would recall at the time. The reason I saw the brief, the reply brief, it says that we won the battle but lost the war. The dismissal of that case had nothing to do with the sovereign immunity or official immunity arguments as to the individual defendant. It was all about that waiver of constitutional immunity. In that case, it was the Gwinnett County DA who didn't just threaten raids. There actually were raids, like in this case. There actually were quote unquote actions taken. And what matters is not whether those actions were taken by someone who was purporting to act under their authority, but it's whether those actions taken A, cause a damage, and B, more importantly for our purposes, is does it raise a threat of further damage? And I don't think anyone in this case would credibly argue that the air freshener wouldn't face adverse action from either Director Green or the city manager who might be added to this case later, or the chief of police. I don't think there's any realistic chance that they wouldn't suffer adverse action if they reopen their store tomorrow without some kind of relief or permission from the court or the city. So it's yes, actions happened, but what's more important is what do those actions tell us about what kind of threat the business continues facing? And I think it's very clear that the business continues facing the arrest of its employees, the seizure of its property, and further raids of its stores if they want to reopen. So that is a very real and concrete threat. The business license to that extent does kind of complicate things because it's already been revoked. And of course, we have not just issues with the timing of the revocation, but the underlying authority to revoke, which we don't think it's constitutional to be able to revoke it without a hearing. Of course, we kind of trod all over that, so I'm not going to hammer that point much more. But I will say, I will pick up on something Your Honor said. Official immunity is for damages. The court in Lathrop, the Supreme Court in Lathrop, was extremely clear that they've never even heard of any case where official immunity has been granted to an individual capacity defendant for prospective relief. And the defendants in there didn't cite a case to the contrary. Neither of the defendants in this case. And when we're actually talking about what the relief is, we're not asking Your Honor to dismiss the charges. We're not asking Your Honor to force them to return the product. We are not asking for any relief based on what's already happened to remedy what's already happened. We are saying that as pleaded in our complaint, there is absolutely clearly a danger to the business unless this court intervenes. And that's all that is required by the TRO statute. By affidavit or verified complaint, is there clearly a risk of injury to the point where intervention will be necessary to preserve the status quo? And have we provided notice? I don't think anyone's going to dispute that there's been plenty of notice. They're here, they got a witness. And so it's really just, is there clearly harm based on the facts alleged? And I think, especially as the city has continued to keep our license revoked, there is clearly a present continuing threat to the business.
Okay. So,
Your Honor, may I add one brief statement?
sure.
Also, one of the elements, as the court is aware, as like
Well,
relates
hang
to-
on. So I was just about to say to
Okay, I'm
Mr.
sorry.
Church that I was asking y'all about sovereign and official immunity because that is the basis of the motion to dismiss. And if the case is subject to dismissal, then I don't need to hear about all of the TRO elements and whether there's harm and whether there's likelihood of success on the merits, et cetera. So to the extent that what you started to say, Mr. Hyman, was definitely sounded like it was going to the relative merits of the request for TRO, I'm going to cut you off and say this.
Okay.
I agree with the plaintiffs that the motion to dismiss on the basis of sovereign immunity and official immunity is not appropriate. And so I'm going to deny the motion to dismiss. And that means that we need to then address the relative merits of the TRO, which we've all sort of been talking around. And Mr. Church sort of jumped ahead when I asked a question about if there was a distinction in official immunity between the CFO and the police chief. And although, as I've said, I have some concerns about whether there's a meaningful difference, at this stage, I don't believe it's enough for me to grant a dismissal based on either official or sovereign immunity of either individual who, although presumably acting under color of their offices as the CFO and the chief of police respectively, were sued in their individual capacities under a theory that they were acting outside of their authority. And so for that reason, I'm going to deny I'm going to deny the defendant's motion to dismiss. So going forward then, Mr. Church, you've already made a good bit of your argument, but if you'd like to add to that in terms of the relative merits and elements of a TRO.
Your Honor, I think I've probably talked enough. And Your Honor, I can tell you've been very deliberate and conscientious in this case, and I appreciate that. That you have read these affidavits, the verified complaint, and I know that that's for most people, certainly me before I became the hemp guy, it's a lot of chemistry and it's a lot of science and just a lot of law too. So these are obviously very complex issues. I'm Your Honor indicated earlier, are we going to dispute certain things like products were bought, products were tested? No, I'm not disputing the authenticity of the lab reports. Not even disputing that at the time they were tested, there might have been a different number than what's on our lab result. I'm not disputing any of that today because that's for an injunction hearing in our opinion. That's when we can put on our expert and he can explain these issues to you in a way that I am probably not going to be as good at. But that said, I think when we're looking at the big picture here, we have this big raid based on the premise that these folks are trafficking marijuana, not just selling pot beneath the counter, trafficking marijuana. And what we have are 8 test results, only 3 of which show any kind of non-compliance. And maybe I should have thrown this in my affidavit, but there is a margin of error, even if it's over 0.3%. There's a negligence budget in the Farm Bill, which is about 1%. So, there's a lot of thorny issues here, and I don't want to get into the weeds.
Statistics make a little more sense to me. The chemistry, definitely not.
Well, so, sorry.
Let me ask one question, and this might not be dispositive of anything. It's just to call it the rule of judge's interest. But are these products that are manufactured in some mechanized way, not by those that are distributing it at Air Freshener, or are these things that Air Freshener is creating and distributing from its store?
That is a great question, Your Honor, and they are not manufacturers. And Georgia, and we'll get into this at a later date, but there's a new law that is going to go into effect in October that is actually going to open up the manufacturing industry in Georgia for these hemp products. Right now, Air Freshener, like almost every other vape store you see, is getting their products from wholesalers or distributors who get their products from manufacturers generally out of state. There are some in-state hemp processors, very different from production. And that's why it's kind of this crazy scenario, which will be fixed, I think, in October 1st, where companies like Air Freshener have to rely on the lab results that they get with the product, because all the manufacturers have these. Right now, it's a best practice kind of thing. In October, it'll be mandatory to have these kind of test results. And here's where I kind of want to avoid going in the weeds if I can, but maybe I can't. There is a problem that is addressed in this new law, which is not yet in effect, which address
July 1st, correct?
There are like 2 little provisions that go into effect in July that are in effect, but really the meat of it goes in October. The Department of Agriculture is right now promulgating regulations. And so there is a problem with some products that degrade over time or can turn into non-compliant products if not stored properly. This new law, Mr. Hyman earlier referenced total THC, which incorporates not just that Delta-9 element, but some of these other forms of THC. So going forward, hopefully this case will never have to, no case like this will ever come up again, because these new testing requirements are going to address these kind of loopholes and problems that create headaches for retailers, police, courts, lawyers. But that's something I alluded to a little bit in my affidavit, that yes, there are some test results in this case that show barely non-compliant products, but there are good reasons for why those showed up as non-compliant. And it doesn't mean the Air Freshener certainly knowingly was selling any non-compliant products. I would add that the new law also makes non-compliance a misdemeanor or a civil penalty, not a felony marijuana trafficking charge. So we believe, looking at that big picture, looking at the mix of different things that are going on, and I know we're not at the point where we're weighing potential harm to either side besides just, is there clearly an injury? But I don't think anyone's going to be disserviced by a short stay, or really a restraining order that just restores the status quo until there's been some more process here, where the city will render its decision. Maybe it's going to be a great decision. Well, maybe we'll like it. Maybe we'll dismiss our case, but maybe not. And then maybe we have to make a decision about how we want to pursue our available remedies. Again, there is zero case law or statutory authority for the notion that we have to seek alternative remedies before we can get a TRO. And even here, we would say that those alternative remedies are insufficient right now. Maybe they won't be insufficient in 10 days, but right now, this business is struggling. This business is facing, just every day, they're still paying their light bill, they're still paying their rent. And over 3 products out of 8 that were tested that came back barely over the limit. So we think a TRO under these unique, narrow circumstances would be appropriate. And so that's how I'll rest, subject to maybe a couple points in rebuttal.
Thank you. Mr. Hyman, your response?
Yes, Sean. And then at the conclusion of this, I'd also probably ask the court, because a lot of times when you're dealing with immunity issues or for a certificate of immunity review, but I'll table that for right now. My response is that basically which is part of Exhibit 4 of the Southport Police Report, in the case supplemental report, the undercover by two of them, the actual store employees actually said, hey, we can get you weed from California, and describes the various types of weed that he can get. This kind of segues into whether or not they were producing something or things like this. And so, and that weed was tested, and that's, which if you isolate just for Delta 9, came out to be the 1.89. But if you look at all the other cannabinoids that are added to the total THC, then it's 20. But the 1.89 is clearly over the 0.3. And that's on page 4 if you're trying to read that, Your Honor. And so what that goes to, Your Honor, as it relates to TRO and one of the factors being adequate remedial law, which the court kind of alluded to earlier in the hearing. And then the other one is the substantial likelihood of succeeding on the merits. And by virtue of the test results and also counsel admissions that they did have contraband that was illegal according to Title II. And then it's not a uniformity clause violation, because it does in the violation section indicate that anything above 0.3 is fair game or considered illegal. And so that is what has occurred. So as it comes down to the meeting the standards for a TR injunction, that there's adequate remedy law and the likelihood of succeeding on the merits, we do have, and it really the distinction, Jan, I think, with some of the other cases that I've I think by virtue of our case coming after some of the other ones, is that there's been lessons learned, I think, from other cities that I think, and it came out during the hearing, that Southport Police Department are aware that only products that exceed 0.3 are considered legal, that products that are 0.3, Delta 9 and below are, fine to sell. So there's not this misconception that Mr. Church is trying to attribute to the city or the police or Mr. Green. They're fully aware of that. And the products that were seized, and he's just saying 8 or more, those are just the ones that they just decided that they sent out to test, but there are other testing that will be done. But you can just see from the record that they do exceed the 0.3. So that was a lawfully effectuated arrest. And so that's just another element that they would not be able to meet under TR or other injunctive standards.
Ever so briefly, Your Honor.
Well, it's your motion, so you get the last word, Mr. Church.
Thank you, Your Honor. Just 2 brief points. First, regarding the incident report and these allegations that any employee at Air Freshener said, we have weed, we get weed, we can get you weed. First of all, that's not what Officer Cornelius testified to as yesterday. I mean, I'm kind of quibbling here. He said that an employee said we have the real stuff, not CBD, which could refer to THC products. But as Officer Cornelius also acknowledged yesterday, there are THC products that are legal. More importantly, we're not even conceding that those statements were made. Officer Cornelius said that these undercover interactions were recorded. We have not been provided with any of those recordings. What I can say, and we alluded to this in our affidavit, was there was previously a raid of a CBD store in South Fulton in 2019. There were similar allegations by the police, not Officer Cornelius, that the owner of that store said they had marijuana, and that turned out to be false. So I'm just asking the court not to give too much weight to these allegations when especially we haven't seen or heard the recording. The second point is Mr. Hyman brought up adequate remedies, substantial likelihood of success. That is the standard for an interlocutory injunction, not a TRO. Certainly, those are 4 factors that we will get into at a later point, hopefully, especially since the motion to dismiss is being denied. But for a TRO, it doesn't matter the substantial likelihood of the merits. It doesn't matter the potential harm to the party being enjoined or the public interest necessarily, although we think all of those things weigh in our favor. We are here today just for a TRO. I want to emphasize the narrowness of what we're asking for. And so we would ask Your Honor to essentially just reset the status quo, even if for a brief pause, so that we get a little breathing room and we can continue working on this case.
Thank you, Mr. Church. Okay, as we have been discussing these issues, I think I've made clear that I think there is something of a difference. Whether it's just a difference to me or if it's a difference without a distinction without a difference, I don't know. But I do think that there is something of a difference between the license process, because even if the petitioners believe that process is inadequate, there is in fact a process. And from that would flow the ability to vindicate one's rights if that process is inadequate or was wrongly decided. And so for that reason, I am willing to grant a TRO, but it's going to be tailored, and just to make things nice and complicated, it's going to be different relative to the two defendants. And so what I'm going to do, is, I am going to grant the TRO regarding, please forgive me, I don't have it in front of me, the correct name. Hang on, for the,
Mr. Green, the financial.
thank you, sir, for the Chief Financial Officer, Mr. Green. I am going to grant a TRO, but what I am going, am I correct that generally, unless it is deferred, that the city council meeting would take up and make a decision at that time? Right? Unless they defer it to a later meeting, right? It's not like they're going to say, yes, we're going to take it under advisement and issue a report. They're just going to vote one way or the other, correct?
That's typically
Believe
what
so,
happens,
Your
John.
Okay. So, and that meeting is scheduled for July the 8th. Is that right?
I believe it's July 9th.
I'm sorry. Okay. July 9th. So what I am going to do then is I am going to restrain the CFO from taking any action against RSRA Ventures doing business as the air freshener depot until July the 9th.
Judge, would you
Well,
consider
let's say
July
July the
10th?
10th. So
Yes, thank
doing
you.
that math as I was looking at it, so that we will have the benefit of whatever decision the city council makes relative to the license. And then if, presuming that decision were adverse to RSRA, then they have the right to seek an appeal and to request immediate, redress relative to that, if that's what's necessary. Separately, as to the police, I do think, as to Mr. Chief Meadows, I believe it is reasonable under the circumstances to restrain the chief of police from threatening or initiating arrests or seizures based on the possession or sale or distribution of hemp-derived cannabinoids, assuming, for a period of 30 days.
And that's at any level, Your Honor?
Sir?
Is that at any level? Because based on what you said, that means that it could be above 0.3.
We would not have any objection to, Your Honor, amending that slightly to say hemp products, even though I think it's baked into the definition of hemp products. You can either cite the statute or
Well,
you could
that's what what I'm referring to are hemp-derived cannabinoids as they are defined in OCGA 2-23-3.
Thank you, Your Honor. That's perfect. I think that leads us back into the uniformity clause thing, but that's a battle for another day.
And
Yes, sir.
then one last thing that, and it's typically what has happened on the denial of the motion to dismiss is the court inclined to grant a certificate of immediate review on that issue?
So let me think about that for a moment. Generally speaking, I'm not very stingy with certificates of immediate review. But a couple of things to keep in mind. One is I don't have an order yet. So and I'm going to ask Mr. Church to provide me with an order.
Okay.
And until I sign that order, although the parties know what my order is going to be, the obligation to file an appeal, that 10 days doesn't start running until I actually
Right.
sign whatever order is going to be submitted to me, and that I will then edit. What I would be concerned about from a certificate of review perspective is if it is the potential for, I don't want to say abuse, but taking advantage of the time delay that would be associated with pursuing that remedy. And so I'm going to put a pin in that one for now. But generally speaking, I don't have any objection when a party they want a certificate of immediate review, as long as I don't think that it is being used to delay. Then I generally am pretty free with that. But I'm going to put a pin in that. Mr. Church, did you have something you want to say on that point?
Just wanted to maybe make a suggestion that is, I think, in line with what Your Honor is considering, which is maybe withholding on that order until after the injunction hearing, where facts will be more developed. And if, of course, there's an adverse ruling on the injunction, either side can appeal from the injunction, whether you grant or deny the injunction. Either side can appeal as a matter of right from that. So it might make more sense just from a housekeeping perspective to keep these things together. And Mr. Hyman, as I've seen in other cases, might want to renew his motion once there have been additional facts and evidence presented. So that's just a thought that you might want to put off entering the order until the injunction hearing has taken place. But that's honestly, your Honor can do whatever your Honor wants. But that's something I thought I'd suggest because that's how other judges have proceeded in similar kind of cases.
Okay. In addition to that, let's have a conversation about when such an injunction hearing would actually occur.
And I'm sorry, maybe it makes more sense to see what the city council does too, before we schedule a hearing, or we can go ahead and schedule one now.
Well, I don't intend to schedule anything before we find out what the city council does, but also because I think that an injunction in this matter is going to take a number of hours to have a meaningful hearing with witnesses, et cetera. That it is something that we might need to target getting on my calendar so that it doesn't run into drug court, which, yes, that is a interesting coincidence that I am also a drug court judge. And also doesn't run into other trial calendars. For example, and leaves that I have in place. So what I'm looking at is the best availability I would likely have is sometime the week of July the 9th, right? July the 8th, right? So I would theoretically could make available the 12th of July. And then beyond that, if it's going to be by Zoom, I can make it, I can do the week of the 15th. Though I'd prefer the week of the 22nd.
I'm sorry, Your Honor, you say you prefer the week of the 22nd?
Not for the hearing. It's just that I can have a Zoom hearing for 4 hours the week of the 15th. I just would rather not because technically I'm on vacation that week, but you know.
We have no objection to the 12th. I think we can get this done in a day. I think they'll call their expert. We'll call our expert. They'll call their officer. That might be it. I think we can get it done on the 12th. Would that be a Zoom or in person?
I generally speaking, if we're going to have evidentiary proceedings, I prefer them to be in person because it just gets a little clunky trying to share evidence and call witnesses.
And this will be the kind of case where we're showing a lot of test results.
Right. So I would likely have it be, let me look at that day.
Judge, if I can, I'm happy for you guys to proceed on the 12th, but I'm on leave on the 12th, so
Okay.
I'm sure Mr. Church can proceed without me on the 12th. I don't want to slow this up any.
Okay. Well, thank you. I appreciate that, Mr. Arrington. Mr. Hyman, so what I'm looking at is the 12th, and I would likely set it to start at like 10 a.m. because I have just a regular civil motions calendar at 9 that morning. And so I would probably start this at 10 a.m. on the 12th of July. Thoughts?
Your Honor, as you're speaking, I'm pulling up my calendar.
Sure.
Why is it this same changing on me? The 12th is on
It's a Friday.
Friday. Let me put this in month view.
That's what I just had to do as well.
Okay. Okay, here we go. The 12th. Ideally, Your Honor, if we could do the 15th, and here's why. By the time we deal with the city council meeting on the 9th and just trying to meet and get the case ready for the 12th, that's my concern, because my attention leading up to the 9th will be focused on council matters, and then having to then try to meet with whatever witnesses that we need to get ready for the 12th. That would be my only concern, Your Honor, or one of my concerns.
Well, so like I said, the only issue with that is that if we have the hearing on the 15th, it will be by Zoom. And I think that's
Okay.
less than
Okay,
ideal.
gotcha.
And I also think that given that these are issues that presumably you would be presenting to the city council, the idea of preparing to then turn around and present those same issues to the court, maybe not that heavy of a lift to go from
Well,
the 9th to that gives you 2 days to the 12th.
It's really not the issues, Your Honor, so much as, for example, we would have to, because this had been referred to, from my understanding of yesterday, just getting all the other supplemental stuff. Like today, we just have like the supplemental report and some of the RAD reports, but getting some of the other evidence and having a chance to go through that. That was my concern. But the issues wouldn't necessarily change, but it's just the additional evidence and getting the proper bodies in place to present that or get those authenticated. Those are the type of
Right. Well, I
issues that-
understand, and I don't want to be difficult, but presumably the city manager is going to have sorted through all of those things, probably with the assistance of the legal department, in an effort to issue whatever decision they're going to issue. And so it feels like all of those things feed off of one another. And to the extent that there are authentication issues or certification of issues, I trust that the parties can be accommodating in good faith about what we all know are, legitimate records, instead of arguing about whether or not, we can get somebody to formally sign a piece of paper or say, yep, these are legitimately the documents of the GBI or whatever the case may be. Obviously, if you feel like your hands are tied when we get closer to that date, then you can certainly share that with me and I will consider whatever continuance motion is requested.
Okay.
But I feel like it makes sense to go ahead and get it on the calendar,
Okay.
so that I can have Mr. Freehoff issue a hearing notice on the 12th of July. It will be in person.
Okay.
And I anticipate that it will be at 10 a.m. But just as I do with my trials and everything else, I strongly encourage the parties to communicate with one another ahead of time so we can dispense with a lot of the procedural preliminaries. If everybody agrees that everybody's documents are admissible with the, a few exceptions that we actually need to have a conversation about relevance or et cetera, then let's please do that. And I've even had hearings and trials, for that matter, civilly, where the parties agreed all in advance that all of these documents are admissible. So you don't even have to do I'm showing you a document that's been marked as Exhibit A. Can you tell the court what that is? We just all agree this is Exhibit 1 and it's already been admitted into evidence to the, with the exception of documents about which there are real disagreements as to their provenance or their admissibility. That's just my request and suggestion. Yes, sir, Mr. Church.
I was going to say, for what it's worth, I try to provide all my exhibits beforehand, and I don't intend on any frivolous objections as to authenticity for things that are clearly, beyond dispute. So we will work in good faith with Mr. Hyman, as he has been with us.
Okay. And last thing is, as I mentioned at the beginning of this hearing, the court does not provide its Court reporter for civil matters, my standing order requires that you retain your own court reporter. Presumably you would want one for that hearing. And so I would suggest to you that you need to make sure that you have one, assuming that the parties want one. And then finally, Mr. Church, if you would please prepare a proposed order for the court's consideration regarding the TRO and the limitations that the court has outlined today, including the denial of the motion to dismiss at this preliminary stage.
Yes, Your Honor. And if I may do that by Monday, I have a doctor's appointment today. I don't know what kind of news I'm going to be getting. Hopefully good news, but if I can do that by Monday, that'd be great.
Yeah,
And Your Honor, will the order be shared with defense with
of course. The only
okay.
the only caveat to that I always say is this is having Mr. Church draft an order and copy you and giving you the opportunity to talk with me is not an opportunity to re-argue your position. It is simply an opportunity to point out, if you believe that is the case, that his proposed order doesn't accurately reflect what the court's ruling is. But I will say it is also not generally my practice to simply sign off on what's submitted to me. I typically will edit it and put it more, edit it in a way that I believe accurately reflects not only what my ruling was, but my understanding of what the issues are. It's just easier to edit than it is to create from whole cloth. Anything else, gentlemen?
Not from us, Your Honor.
Mr. Hunman?
Other than just like I said, once I look at the proposed order, then I more than likely will put in the record a request for certificate.
Okay. And of course, keep in mind that certificate, I certainly understand you're requesting it in terms of the speed with which we will get there. I will go ahead and submit the certificate of immediate review. And here's what I will say. Once I sign the order, if I'm going to grant you the certificate of immediate review, I will immediately sign that and let you know to give you as much time as is necessary to take action. Okay? Thank you all. Have a good day.